All right, welcome back, everybody. We're going to move on to our third topic, estate planning for blended families. And our presenters are Mr. Drew McDowell, financial advisor with Arbor Wealth Management, Mr. Hugh Ross, financial advisor with Polaris Wealth Management, and Ms. Christine Sutherlin, attorney with Dunlap Shipman.
Well, great. Good morning. We're here to kick off this next session. We're going to talk about estate planning for non-traditional families. So here's our agenda, and you guys can see that. We're going to talk about, hey, what is that traditional family nowadays? And then we're going to talk about what that looks like, some traditional family by the numbers. And then we're really going to focus our time on talking about what we call non-traditional families and why estate planning for those non-traditional families is so important. And then we'll wrap up talking about the different types of non-traditional families and some unique planning situations. So I am very fortunate to be here with two of my esteemed colleagues. To my left, Christine Sutherlin, she's an attorney, but you get a twofer. Christine is an attorney with Dunlap Shipman. She graduated with her law degree from the University of Alabama, my nemesis in college football. They just beat us really bad this past weekend. And then she also is not only an attorney, but she's a certified public accountant. So you get a twofer with Christine. To my right, Mr. Drew McDowell, you get a twofer with Drew. Drew also graduated from law school, earned a law degree, but in addition to that, Drew is a certified financial planner. So I am with two young, esteemed professionals, and I am proud to share the stage with them. I'm Hugh Ross. I am also a retired Air Force guy. Spent 20 years on active duty in the military, and then I started my second career in wealth management. I had the pleasure of attending school at the Air Force Academy, but because I grew up in Georgia, I'm a Georgia Dogs fan. So again, I have to sit with a lot of folks from Alabama today. So let's keep moving. So what is the traditional family? If you're my age or older, and I'll give folks the Reader's Digest, I'm 58. So if you're my age or older, you recognize this guy. That's Leave It to Beaver for all the youngsters in the audience that don't know. But when I was growing up, the traditional family was husband, wife, 2 kids, a dog. So for Beaver here, it was Ward and June, Cleaver, and they had their sons, Wally and the Beeve. And that's what most folks my age and older think about when we think about planning. We think about the old traditional family, husband, wife, couple of kids, if you're fortunate, grandkids, and it was all sort of neat and clean. But you don't have that so much today. So let's just look at some numbers. So if you can wrap your head around this, things are changing. So marriage rates for folks born in the baby boomer generation, those are the folks born 1946 to 1964. On the front end of that, about 91% of the folks were married. And there are a lot of reasons for that. But if you think back to the folks on the front end of that, that was coming out of a time when most women either didn't work outside of the home, they were homemakers, or the opportunities in the labor market weren't nearly as expansive as they are today. And so their parents taught them to, go to school, get an education, but look to get married so you would have somebody to help support you and help you start a family and raise children. By the end of the boomer generation, marriage rates are down to about 87%. Then when you cross over into what we call Generation X, those are the young folks who were born between 1965 and 1980. Marriage rates had dropped down to, again, 75% or 80%. And then by the time you get to the millennials, folks born between 81 and 96, marriage rates continue to drop. And those are projected to be about 75%. So things are changing. Not only are the marriage rates dropping, but divorce is going up. So the divorce rate today for folks getting married is about 50%. For those people who get married a second time, goes up to what did I just say, 50, so jumps up to about 60% for a second marriage. And then for a third marriage, it jumps almost to 3 out of 4 get divorced again. And there are lots of reasons that folks speculate, psychologists speculate for why that happens. Folks who've gotten divorced once, some folks say, well, they've been through that and they recognize the signs when things aren't going as well, so they're not going to hang around and tolerate another bad situation. Some folks say they are better established the second time around, so they don't fear getting out on their own. Lots of reasons why, but the reality is divorce is more prevalent now. Today we have same-sex couples. So when my grandparents were growing up, there was no such thing as a same-sex couple. When my parents were, raising a family, if there was a same-sex couple, you didn't know about it. Well, things are changing. So today, same-sex couples, about 61% of them are married, and 16% are raising one or more adopted children. So that, again, traditional family that a lot of people visualize doesn't exist to the same degree it did a few years ago. We also have cohabitating couples. So 59% of the adults age 18 to 44 have cohabitated with a partner. We have people today who are intentionally single parents. So unwed mothers have been decreasing since 2008. However, among women ages 35 and older, some are choosing to be intentionally single parents. So I don't know what's driving all of that phenomena, but I have 2 older sisters, and one of my older sisters is a physician. She's been busy in her professional career, and she just never got married. So you see that more and more. And then another phenomena that's more recent, but is, again, a rising number, is divorce among Americans age 50 has doubled in the last 25 years. So the people we think about when we think about traditional estate planning, we have to set that aside because today we have a lot of non-traditional families. So there are a lot of benefits that most people, when they're thinking of that traditional family, whoa, what's going on?
We're good. A little too far.
Something magic is happening.
You have some automatic timing going on here?
Yeah. We'll go
Hang
back.
on.
There we go.
We want to go backwards.
Let me help you.
Thank you.
You got it.
Yeah, so
Thank you.
when most people think about traditional families, they are assuming a lot of the things that are listed here. So most folks know that there are advantages in terms of Social Security benefits for married couples. As a married person, you can't be compelled to testify against your spouse. You can decide, I don't want to testify against the spouse. You get the benefit of being able to file a joint tax return. You can do joint homestead filing. You can do a joint bankruptcy. One of the most important things that a lot of people overlook is this idea that if you're married, you have benefits under the health care laws, HIPAA, and you can show up and see your spouse in a hospital and make decisions that you don't have if you're not married. And then the idea of intestate inheritance. For a married couple, transferring assets to your spouse is much easier than if you're a non-traditional family. So what we're going to do is I'm going to turn it over to my esteemed colleagues and let them talk a little bit more about the non-traditional family. I'm sorry.
Thank you, Mr. Hugh. Okay. So in preparing for today, by the way, very quickly, I talk fast, but I'm not a fast talker. So I apologize in advance if I go too fast. I'm sorry. That's a joke. It fell flat, but that's okay. Basically, when you think about the non-traditional family, we have to start thinking about examples that we can all relate to. The slide that you see here, what should be playing is the introduction to the ABC hit sitcom Modern Family, in case you're curious. This is actually the end screen of the YouTube video, so we're stuck on Mitchell and Cameron and their daughter Lily. And you might be saying, why do we want to talk about a sitcom when we talk about non-traditional family estate planning? Well, the Pritchett family, which is the family that this sitcom is based on, is the best example of multiple opportunities for non-traditional estate planning that one can think of. And this television show has been on since 2009, recently just had its finale last year. And in case you're curious, in 2015, when the Supreme Court made same-sex marriage legal, in 2015, the season finale was the same-sex marriage of Cameron and Mitchell. So in real time, we see art imitating life, and we're able to draw valuable estate planning lessons from the Pritchetts. So up here is the modern family tree, and this does not include people who have married into the family. So I want to go over this very quickly. Ed O'Neill, everybody remembers Ed O'Neill. He is played by Jay Pritchett, who's the middle head of the family tree there. So Jay's first wife was Dee Dee, and he had 2 children with Dee Dee. He had Mitchell and Claire. Claire is married to Phil Dunphy. If you're familiar with memes, everybody loves the Phil. Good job. He's such an encouraging dad. Claire and Phil have 3 children, Haley, Alex, and Luke. I promise there will be a reason why we're going over the family tree momentarily. Mitchell and Cameron, legally married in 2015, have adopted Lily, a baby from Vietnam, and then Rexford Tucker Pritchett later on in the series. Jay, of course, got divorced from Dee Dee, and later on in life decided to marry Gloria Delgado Pritchett. Gloria is an immigrant to the United States from Venezuela. She is married, was previously married to Javier Delgado. They had one lineal blood descendant son, Manny Delgado, who was later adopted by Jay. And then Gloria and Jay have a natural born child together, whose real name is Fulgencio, but I can't spell that, so we're going to go with Joe. Okay, you've done the family tree. So what estate planning, non-traditional estate planning items can we pull from this family tree? Well, first, Jay got divorced from Dee Dee. So in his original estate plan, he probably named Dee Dee as the primary beneficiary of his estate. That is valuable to know because now Jay is married to Gloria, and Gloria might want to be the beneficiary of some of Jay's estate. But then, of course, we have Claire and Mitchell, who are Jay's children from his first marriage, who Jay might want to benefit from his estate should he pass unexpectedly. So how do we as estate planners draft trust documents or estate planning documents that take care of Gloria and their two minor children, Manny and Joe, while at the same time making provisions available for Mitchell and Claire? To further complicate things, does anyone here know the name of Jay's business, what he does for a living? It's the best thing of all time. So that's Phil is the realtor. That's a good guess, Mark. No, Jay owns Pritchard's Closets, which is a custom closet and blind maker. Their number one competitor is Closets. If you don't think that's funny, comedy isn't for you. Jay owns a business. He is the 100% owner of the business. Claire, after having no career, raising a family for a few years, has decided to come back and run the business for Jay. Now, does Gloria get equity in the business that Jay owns if Jay were to pass? Or does Claire get the equity in the business that Jay owns if Jay were to pass? Because Claire is the one running it for Jay now that he's retired and playing golf. These are all estate planning questions in a non-traditional family that is more common than you would think. Because as Mr. Hugh just mentioned, 50% of the marriages in the United States end in divorce. That number jumps for second and third marriages. We have to make provisions for children from first marriages, children from second marriages, perhaps even children from third marriages. And fun factoid, in case you're curious, you can see Manny there on the right-hand side of your screen. Manny is the lineal blood descendant of Gloria and Javier, but because the Pritchards live in California, which is a second parent adoption legal state, Jay is able to legally adopt Manny. That is not the case in all 50 states. So you might think, hey, Manny was not born in the United States. He's not a United States citizen by birth, but he becomes a citizen through his mother. The planning opportunities are endless. So when you're looking for non-traditional estate planning opportunities, look no further than reruns on Fox. So moving on, a couple of different types of non-traditional families. A lot of people, when they think about non-traditional families for estate planning purposes, they might say to themselves, well, my family, we don't have any same-sex couples in my family, so I don't need to worry about non-traditional estate planning. I would counter to you that statistically is probably not the case. Number one, and Christine is going to take over a couple more of these, but I want to just go through them very quickly. Number one is divorced couples. You might be saying, like, that's an oxymoron. It is an oxymoron, but it happens more than you would imagine. Two people, whether they be same-sex or opposite sex, get married. A few years later, they decide they don't want to be legally married anymore, but they cohabitate. That is incredibly common these days. Or they maintain common financial interests because they have children together. So they don't get remarried to anybody else. They probably want to benefit each other in some way in their estate plan. But as Mr. Hugh mentioned, the default benefit of being married means you get some intestate protection if you are married, but if you are legally divorced, that has been severed. So estate planning would be necessary there. Cohabiting couples. Amongst millennials, this is probably the most fast-rising cohort of people that need complex estate planning. If you are not legally married, again, the state does not really want to give you a lot of freebies. So you do need to make proper estate planning goals there. In addition, if you have children together, but you're not legally married, so a cohabiting family there. Blended families, everyone knows where we're going with this, and Christine will take that momentarily. Obviously, same-sex couples. Intentionally single parents are incredibly interesting. This is becoming more and more common, obviously, with the rise of in vitro fertilization. As Mr. Hugh mentioned, single motherhood is on the rise amongst women who are over the age of 35 in the United States. And by the way, all of our statistics came from the Pew Family Research Council, in case you wanted to Google them. So those intentionally single parents, there are documents that you might not think about that would be incredibly powerful for a person that doesn't have a a spouse who can make medical decisions for them or make financial decisions for them should they become incapacitated. And I want to jump back very quickly. This wasn't a part of my plan, but I'm going to do it real quick because I can. And I spoke too soon. Oh, go back one? Okay. Okay, very quickly. We are here, we're watching this online digitally. Thank you all for tuning in at home. We really appreciate you guys being here in person as well. There is an estate planning document that I guarantee you that very few people have drafted, that the lawyers in this room will say you need to have drafted. And we are here on a college campus. It is incredibly powerful. Haley, Alex, and Luke in the series all go off to college. They should have living wills, durable power of attorneys, and medical directives. They should have those documents in place. We're here on a college campus that has been shut down by a global health pandemic. There are students in the United States who have been hospitalized who live 10 states away from their parents. Their parents need to have those documents so they can fax to the hospital and say, yes, please, I need to be able to talk about my child's care, especially if you have a blended family, a cohabiting couple, a divorced family where the child's last name may not be the same as yours, but you are that parent's legal guardian or that child's legal guardian. Those are the types of kind of evolving estate planning concerns that we need to think about, and very few people think about documents for young children. So I think that's incredibly interesting. And then, so I will show up. The last one, though, Bachelor Spinster by choice. Obviously, this is an interesting estate planning opportunity because you have to say, hey, you are accumulating assets. To whom or what are you going to leave these assets to? And should you become incapacitated, what trusted person do you have to take care of you? Those are all, I guarantee you, if we think in our Rolodex of family relationships and people we know and love, surely everyone here has a friend or family member that falls into one of these categories to whom non-traditional estate planning would be very important. So without further ado, I will be quiet and turn it over to the expert, Christine.
Bingo.
Okay, so I'm going to talk briefly about blended families. We have the Brady Bunch. Everybody in, I believe, every age group knows about the Brady Bunch. And, I think probably back when this show was filmed, the Brady Bunch was maybe an anomaly because everybody was the traditional family. I do estate planning for clients of all age groups and varieties. And in this day and age, the yours, mine, and ours situation is increasingly more common. I guess the good news for the Brady Bunch is there are estate planning, there are documents, that anything that you want to accomplish through estate planning generally can be done. You just have to have a candid conversation with your advisors. The bad news for your non-traditional families, even though they are becoming more of the norm, is that things are not quite as easy for the Brady Bunch scenario as it was for the Leave It to Beaver family, because the laws are just not set up. The laws haven't been enacted to protect this family as much as it has the traditional family. So estate planning for your blended families just becomes even more important than it is for everybody else, just to make sure that you let your advisors know what it is that you're trying to accomplish, and you have candid conversations with them. Nobody benefits if you come to your advisor and want to act like your family is perfect or your non-traditional family is the traditional family. Everybody needs to be on the same page and know exactly what you're trying to accomplish. So just a few kind of thoughts and ideas for you guys. There isn't any, as I believe some of the earlier speakers alluded to, there's no black and white, one-size-fits-all plan for every family, even traditional families, but especially not in the case of a blended family. So for your blended family, your plan is going to be very unique to your particular circumstance that you're in and your particular goals that you're trying to achieve. But just a few issues that run up in blended families, and Drew alluded to them with the family tree for Modern Family. I'm not as much of a Modern Family guru, so I don't know all the names. But basically, the tough situation that you're placed into when you're in a situation like this is you know, you have married some your second spouse or your third spouse. Obviously, you love that spouse and you want to protect that spouse. On the flip side, you have children that are not your spouse's children. So your spouse, their primary objective is to protect their children in some situations. So you're kind of stuck in the situation where you want to make sure that both your spouse, your biological children, and your stepchildren are all provided for, and how that looks for each family is, you know, is a lot different. As Drew and Hugh both alluded to, you know, if you're in this blended family situation, you know, most of the time you have been divorced previously. So you may have had estate planning documents that were drafted prior to your divorce. And by operation of law, any devise or anything that you've named for your ex-spouse is going to be invalidated by that divorce. Well, in some situations, that's a great thing. In some situations, you know, if you and your spouse are still trying to provide for your children, then that's not what you intended, and a lot of people don't know that that's how it works by operation of law. On the flip side, some people say, okay, well, I'm divorced, so nothing that I gave my spouse, nothing I named my spouse in is going to be valid, and that's not necessarily the case either. So at the outset, at the time of the divorce, you need to meet with your financial planners and advisors and see what kind of changes need to be made to make sure that your plans reflect whatever it is that you and your ex-spouse agreed on. Then going forward, for the blended family, if you don't have any estate planning in place and you have a spouse and you and your spouse have children from prior marriage that are not your children together, the intestacy statute is going to give your spouse 1/2 of your estate, and then your children are entitled to the other half of your estate. Well, in this case, you know, you may have intended to provide for your stepchildren. Well, your stepchildren, since they're not your biological children, are going to receive nothing. On the other side of that, you know, your spouse may have received a hefty settlement from his or her prior divorce, and you might not think that your spouse needs that whole entire half of your estate. So it's very important that you have these conversations with your spouse and your financial advisors just to determine exactly what it is that you're trying to accomplish. In most situations for the blended family, again, not all, you know, it's even more beneficial to set up a trust of some sort than it is, you know, a trust for a traditional family. Generally, is going to help you avoid probate. It's going to set some restrictions maybe on distributions for your children. Well, in the case of a blended family, you know, that is probably the most likely or the best tool to be able to provide for your spouse, but make sure that your children and your stepchildren are still provided for at the end of the day. I believe Drew is going to talk about some more of the issues that face single families or single parent families. So, you know, in the case of a blended family, you do have a spouse, so you do have somebody who automatically by operation of law is going to have access to your health care records and other things like that. So while a living will is important in a blended family, it's not as vital as it is in some of the you know, single parent situations, which I believe Drew was going to touch on.
For sure.
Here you go.
Thank you very much. Thank you, Ms. Pugh. Okay, so getting off of the Brady Bunch. Oh, by the way, so obviously the media not working is not as ideal as possible, but I do want to, okay, quick crowd reaction, yell it out when you see it. What, one more slide forward, come on, let's go. What movie or television show does this clip come from? Oh, no. Oh. It was so fast. We're fighting, all right.
Fight each other.
We'll go one forward, please, sir. And one more forward. Okay, what does this come from? Cinderella. Why is Cinderella important for estate planning? Cinderella's dad did not have a Q-tip trust. Cinderella's dad owned the inn. He owned the nice building that Cinderella was able to live in. And then Cinderella's dad marries the evil stepmother, who you see right here. And she has the two evil stepdaughters. And they make Cinderella night and day Cinderella. They make her clean and cook and everything. And she has to live in the attic, and the daughters get, all the benefits of being the evil stepmother's daughters. If you had a Q-tip trust, which you're not supposed to stick in your ear, but you Google Q-tip trust, that would be an opportunity for Cinderella to have beneficiary ownership of the house that technically should be hers because it was her father's before her. And instead, we get the evil stepmother who makes her do all of the work and get none of the benefit. But eventually, we all know it works out well for Cinderella in the end. But proper estate planning would have made this story not as interesting for Walt Disney. So I guess we'll kind of jump around a little bit, I guess. We'll talk about same-sex couples very quickly. Prior to 2015, as most everybody knows at home and here as well, same-sex couples provided a lot of very complex estate planning opportunities, mainly because they were not recognized by our state intestacy statutes. Now that the Supreme Court has recognized same-sex marriage, a lot of the traditional sort of who gets my stuff if I were to pass away, who has legal visitation rights in the hospital, who would be the default person to make financial or medical decisions, that has kind of all been taken care of, thankfully, which makes everyone's estate planning lives easier. But there are still some concerns, obviously, namely when you're talking about same-sex couples that are raising children together. That's something that should definitely be managed, and that's one of the biggest concerns from a planning standpoint, because again, currently, we treat same-sex couples as if they are opposite-sex couples for statutory purposes, but our laws have yet to kind of really catch up when we're talking about children that are being adopted. Intentionally single parents, incredibly interesting as well. Love talking about the opportunities there. If you are divorced, or if you just choose to have children on your own, whether you adopt them or have them naturally if you're a female, then you'll be able to obviously have a lot of documents for yourself, but also documents for your children. And one of the things we always recommend, if you are a single person with children, you need to meet with an attorney to talk about who is going to have legal guardianship, who's going to have control over your children should you pass or become incapacitated, and then who's going to have control over your assets should you pass or become incapacitated. And I think a lot of the lawyers in the room will shake their heads in agreement. Sometimes that doesn't need to be the same person. Sometimes you need to have someone who's the financial head of household, and sometimes you need to have someone who's the care head of household. A lot of times that happens to be the same person, but checks and balances work in the government. It works at home as well. One other thing to think about is obviously if you do pass unexpectedly, you're not able to make those discretionary control decisions over your money. One, our favorite acronym for lawyers to throw around is HEMS, Health, Education, Maintenance, and Support. Obviously, health, education are pretty simple and self-explanatory. Maintenance and support open to a little more interpretation. Who do you give that HEMS power for distributions to your minor children or even children that have gained the age of majority? Who has that power, if at all? And then, of course, age of inheritance for children. I'm sure every lawyer in this room can tell you, and financial advisor, CPA, it doesn't matter. Everyone can tell you about instances where a client has come to them and said, I love my children so much. They're the best thing since sliced bread. I do not trust them with a dime of my money. And, number one, so who's doling out that money? Who makes the decisions? Who has to have the legal responsibility to get sued if the child doesn't like that decision? And then do they get access to, the full principal of the money, if ever at all? Those are all things that need to be discussed, especially if you don't have a spouse to fall back on should you become incapacitated or pass unexpectedly. Am I going over your stuff, Christine? Do you want me to keep going? Keep going? All right.
Keep going.
Families with non-marital children. This is becoming more and more popular and prevalent in our society. I mentioned second parent adoption. That really came out of the Supreme Court legalizing gay marriage and same-sex, I should say, same-sex marriage. even unmarried couples, so cohabiting couples can legally adopt each other's children. That would not require that the legal rights of the child's natural lineal blood parent be extinguished. So a lot of times in our planning scenarios, people think, let's see, a husband and wife have a child, they get divorced, and then the wife decides to get remarried. The second father can legally adopt that child, and it does not require that the actual lineal blood father of the child have his rights be extinguished. That is not the case in all 50 states. It is legal in Florida. It is not legal in Alabama. Definitely something that's interesting, because when you think about it, you may, as the second parent, want to include that child in your estate plan, and so you legally adopt them. They get all of the intestacy protections, so the statute treats them as if they're your lineal blood descendant. But if you don't legally adopt them, they have no rights under your estate plan. And you may still love that child very much and want to provide for them, so that requires some additional estate planning work. Bachelor Spinster planning, it's a terrible term. I can't, anyone comes up with a better one, holler it out. In short, we all have to think about the best decisions we can make for ourselves. Again, I'm not a coronavirus alarmist. I just think it's a good example and opportunity for us to think, if you are a single person, hey, maybe it's time to think about who is going to have my designation of healthcare surrogate. Because, goodness forbid, something bad medically happens to me. I want to know that my trusted loved ones are making decisions for me, and I don't want there to be delay. I think we can all agree that kind of the worst case scenario is you go to the hospital and you've got competing parties saying, well, I'm Drew's mom, and Margaret is watching at home. Hey, Mom. See, that's funny again, guys. This doesn't have to be serious. Mom wants to come in and make decisions because that's what moms do. My brother, spouse, other people might want to come in and make decisions for me. So we want to make sure that we have a clear line of succession for making those healthcare decisions for single persons. And obviously, since joint ownership of property is not an option, if I own a house, which I do, I want to make sure it passes to who I want to get it. A trust makes the most sense, because obviously I don't have another person who's just going to, by default, get my stuff and make decisions for me. So that's an interesting planning technique there. We can, you want to go back to blended families again?
Yeah,
let's do that.
I did have
Yeah.
something to add on the Bachelor and Spinster
Yeah.
planning. Let's see, we'll go back. Well, we don't need the slide anyways. A lot of bachelors and spinsters think, okay, well, I don't have children, I don't have a spouse, I don't really have anybody to take care of. I'm fine with the way that my estate would pass through the intestacy statute. I will say, in my experience, I believe Jim's going to talk about will contests and trust disputes after this. In my experience, these are the estates that are most likely to have, or a lot of cases, have the challenges, because there isn't any clear-cut person. There isn't, this is my spouse gets everything, or my children get everything. You have these distant relatives who've never been involved in Aunt Sue's life, all spending all of this money to fight over something that they didn't even have any idea that they were possibly entitled to. So the Bachelor and Spinster planning, even though you don't have a spouse or children, is vital so that the courts and the attorneys and the financial planner, or not financial planners, attorneys and experts don't end up taking all your money in a will contest. You want to make, if you don't have anybody in particular that you want to leave things through, there's so many charitable devices or instruments to facilitate charitable giving. So you can't say enough about how important planning is for these couples. We will, or not these couples, these individuals. I guess we'll go back to blended families.
Sure, very quickly, yeah.
Okay.
Well, I'm sorry, I apologize. I think we skipped. We went too fast, or I went too fast. Like I said, talk fast, not a fast talker.
Okay.
I just think this is really interesting. When you think of the Brady Bunch, think of our blended family planning opportunities, okay? I think they lived in California. Was the show was set in California? California recognizes second parent adoption, so we know that Mike and Jan can adopt all 6 of the kids. They can be legally each other's children. That's not that big of a deal, but one thing to bear in mind is what sort of estate plan do the Bradys have to have in order to make sure that all 6 of their children share in the assets should, goodness forbid, something bad happen to one or both of the parents. You know, usually when you're talking about blended families, you're not talking about a yours, mine, and ours situation. Usually it's, I have children from my first marriage, maybe the other spouse doesn't. And so then you get into, well, what family assets, like the family farm, or, you know, my grandfather's antique shotgun, what do I want to keep in my lineal bloodline, even though I love my adopted children very much, or I love my spouse very much? I don't want the family beach house that Laura mentioned. I don't want that to go to a different line. I want that to stay in my family. All of that can be done very, very easily through attorneys that practice estate planning law. I don't do that anymore, so I'm saying it's so easy. And so, yes, all of that can be accomplished very easily. So I think we could do questions. Yeah, if anybody has.
We'll do some questions,
Yeah.
but let me make one quick point, just to take us back up to the 30,000-foot level. Whether it's a traditional family, a blended family, it doesn't matter. Remember that estate planning is really about people. Forget the stuff. It's about people. And it's an opportunity for folks in all those categories to think through 2 critical questions. What do I want to happen if I become incapacitated and I can't make decisions for myself? Okay? So, unfortunately, with COVID, we've had young and old go in the hospital, be on ventilators, not be able to speak for themselves. Somebody has to step in. And in some cases, that somebody is somebody who knows nothing about them, because the people who do know something about them aren't there. They're not in the same geographical location, and the people in the hospital don't know who the next person is, and that person can't speak for themselves. So that's a critical question, whether you're part of a traditional family, you're single, is what do I want to have happen if I become incapacitated and I can't make decisions for myself? I can't speak for myself. I can't handle my own personal affairs. And then the second question is, now if I pass away, or when I pass away, what do I want to have happen with my stuff? And there is no rule that says it has to be a certain way, unless you die without ever having done any work to decide that for yourself. That's when the state laws kick in to say, okay, here's how your stuff gets divided. And that's why we offer these estate planning days, to try and encourage people to just stop and think through. Don't get overwhelmed with all the techniques that we talk about. Don't get overwhelmed with all the tax stuff. There are professionals who can help you, but you have to decide for yourself, what do I want to happen, and who do I want to speak for me if I can't do it myself? And then what do I want to have happen with the stuff I've accumulated in my lifetime when I pass away, whether that's unexpectedly or when I'm 150. So with that, let's go back and take any questions anybody might have.
Okay, I can understand that, but.
Okay, so the question, I'm gonna try to summarize and restate it, is basically there's a blended family in the audience. The question is, I had said stepchildren didn't have any rights to inherit, so the question is which stepchildren or which children do have rights to inherit. So I guess at the high level, if you have any sort of documentation, a will or something in place, that was only stepchildren don't inherit by virtue of law. So if you have any documents in place, you have a will that says, you know, I give to my 2 children and my 2 stepchildren, X, Y, and Z, then that eliminates the problem entirely. If you don't have any estate planning in place, say you guys, you have bank accounts or you own your house as tenants by the entirety as husband and wife, well, then the survivor of you is going to get the whole entire estate. And then only the survivor of the 2 of you, their children, would by operation of law be entitled to receive any assets of the estate. Unless the survivor of you then goes back and does some estate planning and says, no, this is not the way that we wanted it to work. We want it to be split between the 4 children equally. Then that can be done. But if you don't have anything in place, and you have things set up to where, if you have beneficiaries named, like on a bank account, and you've named your spouse, then everything is going to go into your spouse's estate. If you don't have any beneficiaries named on anything, you don't have any estate planning in place, the intestacy statute would give 1/2 of your estate to your spouse and 1/2 of your estate to your children, and then your stepchildren wouldn't be entitled to get anything until their biological parent passed away.
And that's a great question. And to kind of take it a step further, like I think the biggest fear that a yours and mine family has is, goodness forbid, one of the spouses passes, and then there's it's a terrible term, but like a nursing home marriage that everyone has seen before. One of the very first things when I got my legal license, I had a 91-year-old man come to me and said, I need a prenup, I'm getting married tomorrow. And I said, oh, that's awesome, congratulations, how long have you known her? And he said, 3 weeks. And so, as you can imagine, his children were not super pleased about that. And so, to Christine's point, if you have no estate planning documents at all, stepchildren don't have a lot of legal rights. But the way that you protect not only your lineal blood children, your spouse, your stepchildren, and then prevent that, later term in life marriage from messing all that up is through talking to one of the attorneys here and having proper trust planning in place, I would say.
Let me just make one other point. We all know families where there are children, but the children are detached from the parents. The children, for whatever reason, aren't active in the lives of the parents. But the niece is. Okay, but if you don't do any estate planning, the law says, oh, this person passed away, they have these children, that they are lineal descendants, and so the stuff is going to go to these children. Well, that's not necessarily what the decedent would have wanted, because it's the niece who's always taken an active interest in their life and supported them and on and on and on. That's why it's important for people to, no kidding, think through, what do you want to have happen with your stuff? And your plan should reflect what you want. It shouldn't reflect necessarily what somebody else wants. So when I talk to clients and prospective clients, I joke about it, but I'm serious. It's interesting what your children want, but it's not their stuff. It's your life, and it's your stuff. And so you have to think about that, and I'm certainly encouraging folks to have that conversation as a family, but ultimately you have to decide. Then the professionals can help you get all the right documents and paperwork done so that what you wanted actually happens. Because if you don't do it, over and over and over and over, we see cases of things that get drug out and litigated, and all of that could have been avoided if somebody just had a good plan in place for themselves.
Definitely.
So,
And then I'm not trying to talk more. I'm going to kick this to Christine. For those of you watching online, thank you. You can chat in questions anytime. Thank you for doing that. Miss Elizabeth Coatsworth has a question, Christine. Which protects one the most, a power of attorney, a will, or a trust?
Thank you for the question, Elizabeth.
Yes.
Okay. Thank you for the question, Elizabeth. So I guess just at a basic level, a power of attorney is a document which plans for incapacity. So this document is going to say, or unavailability. Say you get stuck in Europe due to COVID, then the person that you've designated as your power of attorney is the person who is able to take care of your finances, your assets, take care of your property, pay your bills, and that would be in the event of your incapacity, unavailability. At the moment of your death, that power of attorney no longer has any effect. So then your estate is governed by the terms in your will or your trust. In terms of the will or trust, which provides the most protection, they're just completely different documents. If your plan is to avoid probate, or if you want to spell out the way that your assets are going to be distributed to certain people, some things will be held for longer. You have a trustee that you want to make sure that somebody who is having trouble managing their finances doesn't get assets, then you're absolutely going to need to have a trust to spell out all those wishes. Your will is a simpler document, but it is by no means unimportant. Your will, you name who you want to have to get the assets of your estate, but it's generally more of a short term. I passed away. I have 2 children that are 50. They're responsible adults, no problem. I want my estate distributed 50-50 to these 2 kids, and then that's the end of the will. The trust is generally for more long-term planning and can help avoid probate, but a will and a trust are both very important documents and both provide a lot of protection.
Definitely. Thank you. And that's all the questions we have from the
Right.
chat.
Great. Yes, thank you, guys.
Hancock Bank and Whitney Bank first worked together in 1918. In 2011, the 2 banks merged to become one company built on 5 timeless values: strength and stability, honor and integrity, commitment to service, teamwork, and personal responsibility. With this foundation, our mission is to help you reach your dream. One bank, one mission, 100 years in the making. Hancock Whitney. Your dream, our mission.